On December 1st, 2021, the Supreme Court heard oral arguments in Dobbs v. Jackson Women's Health Organisation. 6 months later, the court would overturn Roe v. Wade. Eliminating the constitutional right to abortion that had existed since 1973, during oral arguments, the justices who would vote to overturn Roe claimed to be applying neutral legal principles. Their questions reveal something different. Here is what was said. Justice Kavanaugh began by asserting the court's neutrality.
I think the other side would say that the core problem here is that the court has been forced by the position you're taking and by the cases to pick sides on the most contentious social debate in American life, and to do so in a situation where they say that the Constitution is neutral on the question of abortion. This court should be scrupulously neutral on the question of abortion, neither pro-choice nor pro-life.
Scrupulously neutral were his words. However, Justice Alito, who would also vote to overturn Roe, immediately framed the issue in moral terms.
The fetus has an interest in having a life, and that doesn't change, does it, from the point before viability to the point after viability?
This is a moral position, not constitutional analysis. Justice Sotomayor identified this directly.
How is your interest anything but a religious view? The issue of when life begins has been hotly debated by philosophers since the beginning of time. It's still debated in religions. So when you say this is the only right that takes away from the state the ability to protect a life, that's a religious view, isn't it?
Justice Thomas, who had participated in abortion cases for 3 decades, then asked a surprising question.
I understand we're talking about abortion here. What specifically is the right here that we're talking about?
It's liberty, Your Honor. It's the textual protection in the 14th Amendment that a state can't deprive a person of liberty without due process of law.
The 14th Amendment's Liberty Clause is the same constitutional foundation the court has used to protect interracial marriage, contraception access, and same-sex relationships. Justice Thomas was familiar with this precedent. Justice Barrett, who would vote to overturn Roe, suggested adoption eliminated the burden of forced pregnancy.
Why don't the safe haven laws take care of that problem? It seems to me that it focuses the burden much more narrowly. There is, without question, an infringement on bodily autonomy, which we have in other contexts like vaccines. However, it doesn't seem to me to follow that pregnancy and then parenthood are all part of the same burden.
Pregnancy itself is unique. It imposes unique physical demands and risk on women, and in fact has impact on all of their lives, on their ability to care for other children, other family members, on their ability to work.
Justice Barrett separated pregnancy from parenthood, treating the physical demands and risks of pregnancy as insignificant. Justice Alito then made a revealing comparison. He equated Roe versus Wade to Plessy versus Ferguson, the infamous 1896 case that upheld racial segregation.
So suppose Plessy versus Ferguson was re-argued in 1897, so nothing had changed. Would it not be sufficient to say that was an egregiously wrong decision on the day it was handed down, and now it should be overruled?
This comparison reveals how Justice Alito viewed women's reproductive rights. Plessy allowed states to mandate racial segregation. Roe prevented states from banning abortion. Alito equated protecting women's autonomy with enforcing racial segregation, suggesting both were moral wrongs that needed correction. This is not neutral legal analysis. This is a moral judgment. Justice Kavanaugh then compared overturning Roe to famous cases that expanded rights.
If you think about some of the most important cases, the most consequential cases in this court's history, there's a string of them where the cases overruled precedent. Brown v. Board, Baker versus Carr, West Coast Hotel, Miranda versus Arizona, Lawrence v. Texas, Knapp versus Ohio, Gideon versus Wainwright, Obergefell. In each of those cases, and those are some of the most consequential and important in the court's history, the court overruled precedent.
I
I think that there are really two key distinctions. And the first is that in the vast majority of those cases, the court was actually taking the issue away from the people and saying that it had been wrong before not to recognize a right. Here, the court would be doing the opposite. It would be telling the women of America that it was wrong, that actually the ability to control their bodies and perhaps the most important decision they can make about whether to bring a child into this world is not part of their protected liberty.
The Solicitor General noted that each case Kavanaugh cited expanded individual rights. Overturning Roe would mark the first time the court removed a constitutional right. Justice Sotomayor warned about potential damage to the court's legitimacy.
Will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts? I don't see how it is possible.
Justice Breyer issued a similar warning, quoting from Casey.
To overrule under fire in the absence of the most compelling reason to re-examine a watershed decision would subvert the court's legitimacy beyond any serious question.
Justice Sotomayor provided the historical count.
What hasn't been at issue in the last 30 years is the line that Casey drew of viability. There has been some difference of opinion with respect to undue burden, but the right of a woman to choose, the right to control her own body, has been clearly set for since Casey and never challenged. You want us to reject that line of viability and adopt something different. 15 justices over 50 years have, or I should say 30 since Casey, have reaffirmed that basic viability line. 4 have said no, 2 of them members of this court, but 15 justices have said yes, of varying political backgrounds.
15 justices had affirmed the viability standard. 4 had opposed it. The minority position would prevail. Chief Justice Roberts focused on time limits rather than constitutional rights.
So viability, it seems to me, doesn't have anything to do with choice. But if it really is an issue about choice, why is 15 weeks not enough time?
For a few reasons, Your Honor. First, the state has conceded that some women will not be able to obtain an abortion before 15 weeks, and this law will bar them from doing so. And a reasonable possibility standard would be completely unworkable for the courts. It would be both less principled and less workable than viability, and some of the reasons for that are without viability, there will be no stopping point.
The Chief Justice discussed weeks while the advocate discussed fundamental equality. The Solicitor General stated the principle at stake.
The court correctly recognized that this is a fundamental right of women, and the nature of fundamental rights is that it's not left up to state legislatures to decide whether to honor them or not.
Justice Kavanaugh continued to claim neutrality while preparing to let states ban abortion entirely.
As I understand it, you're arguing that the Constitution's silent and therefore neutral on the question of abortion. In other words, that the Constitution's neither pro-life nor pro-choice on the question of abortion, but leaves the issue for the people of the states or perhaps Congress to resolve in the democratic process. Is that accurate?
Right. We're saying it's left to the people, Your Honor.
6 months later, the Conservative majority issued its decision. This majority consisted entirely of justices appointed by presidents who had lost the popular vote, including 3 appointed by a president who had explicitly promised to overturn Roe. They stated they were interpreting the Constitution. The oral arguments demonstrate they were advancing philosophical and religious views about when life begins and whether pregnancy burdens matter. Today, abortion access in America depends on state geography rather than constitutional right.